Hey there, Bill Chatt, Bob Prince with the Cervantes Chatt and Prince Legal Minute. Today we are going to talk about access within associations as pertains to the right of the association to get into a unit when need be. Obviously, if we've got a gas leak or something like that, I don't think anyone's going to question the fact that we might knock down a door and go stop the gas leak.
Call the police, they'll help you.
Yeah, we're going to prevent the building from blowing up. I doubt anyone will second guess that. But what we're having, and we've got a lot of active cases going on right now, is where it could be anything. It could be a hoarding situation. It could be, we think there's a leak. There's something that might be going through the common elements through your unit. No, nonetheless, we need to get in, and we need to look around. And we've got unit owners saying, no, I don't have to let you in, which is entirely wrong.
Yeah, the Economy and Property Act specifically says they have an obligation to provide us with access. So if we're in a condo association, that's the argument back. And like, this is going to be a very expensive hill if you want to try to climb this hill. Because generally speaking, the attorney's fees and costs that we incur are charged back to the owner. And, you know, we obviously don't want to have to do this, but unfortunately it's becoming a larger part of the practice because owners become obstinate about whether or not they should have to provide access to the association.
Now that said, not all declarations, but a lot of them that we look at will also have that language in there. And usually the way I see it written is, if you read it, it's pretty much like, we give you notice and we could go in if we wanted to. In this day and age, I think we always tell our associations, don't do that. Don't just put a thing that says 48 hours and we'll be in or whatever. Despite that language that I see in declarations, I do a demand, and if they don't give us access, we go into Chancery Court, which is the court that does things or makes people do things. It's not necessarily a money judgment court. So we go for an injunction. We say, give us injunctive relief. We've made demand. Here's why we need to get in. And I don't think we've lost a case yet.
Yeah, I mean, there's obviously cases where judges don't like it if you don't have the information, such as if you're trying to bring up a hoarding situation, but you only got the information of the hoarding because of, you know, another attempted access through a water leak or something like that. Judges don't like that. But when we have a situation where the association is trying to do maintenance and they're being prohibited from doing that in one way, shape, or form, the association needs to have access, and the courts generally find that the association needed to be provided with this access. Some of those cases are done really quick. Usually it's after some type of temporary restraining order or early in the process, the unit owner comes to terms with the fact that this is going to happen because the court usually explains that's going to happen this way. And the case is generally resolved before a whole lot of attorney's fees get incurred. But sometimes we have those cases where there's going to be a lot of attorney's fees no matter what. You know, like the process, like Bill said, like I generally like to send a demand notice at a minimum, even if the association's provided notice, in the absence of some type of exigent circumstances. So even if it's not a gas leak, there might be an instance where you need to be in there in 48 hours. You send the 48-hour notice, or you put it on the door, and if they don't respond, I generally tell you you can't break in. You don't have the right to do that. Unless you think there's a dead body in there for some reason or some other major emergency, you can't break the door down and get a new locksmith in there. So we have to use the court route, and you do have to look at some declarations have specific provisions about what you have to do in order to charge back cost to owners for things and repairs inside the units. So if there's a provision in the documents that says you have to give them notice for a certain amount of notice by a certain method, there's a case that just came out recently about what method will be used, you have to adhere to that. And if you don't adhere to it, you might not be able to charge it back to an owner.
Yeah, the one you're talking about was the certified mailing. And, we get that a lot of times. Well, that'd be a lot of money. Well, yeah, I'm sorry, it's in your declaration. And now the First Circuit has pretty much said, yeah, that's a thing, so you're going to have to do it. And then the other thing maybe to touch on is, sometimes it's really bad. It could be a pretty pervasive leak or something like that, i.e. an emergency. And so there's also emergency injunctive relief. We always have to start with a complaint. We always have to put in, we're coming in for an injunction. And then if it was so bad that our property manager said, look, there's a waterfall in the unit below, we could go in and say, hey, we have an emergency. Complaint's still out there, Your Honor, but you got to let us in now. And again, the judges are generally going to let us do that. And there's so much other language we can rely on in the declaration, especially if we're talking about, we had something with air conditioner lines. So if it's passing through one, more than one unit, we can say, hey, look, this paragraph here says this is a common element, even though it's by their unit. The reasoning we've had from so many unit owners I checked it myself. Sorry, that's still not good enough. We're responsible for all units, anything that involves more than one unit. So we have to be the ones as the associations to ensure that the problem is remedied.
Yeah, and in the event you have that emergency situation, I like to call the police. The police are a great gauge. If they're not comfortable knocking the door down with you on video, then you don't do it.
It's a civil matter.
Yeah, they'll say it's a civil matter, and then civilly you file your lawsuit in court. Generally speaking, they hear water, they hear gas, they hear potential injuries inside. They are happy to help you and document the situation to make sure that an owner doesn't say that you stole their gold bullion that was stored in their unit.
And just to kind of clarify Bob's point, we're not saying always when you have these issues, call the police first and then calls. I mean, talk to us first. I mean, again, to Bob's point, you hear screaming, fire, water coming out of the, yeah, go ahead and call the police. But other than that, Bob's point is that the police are a very good indicator of whether or not you're going to have to file a suit or not. Because when they say, hey, that's not for us, then you're going to know you're going to have to file a suit. So I think that's...
It's access claims in a nutshell.
Yep. Thanks. We'll see you again.